Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and today we will be dealing with some MCQs from a very important topic, that is the important Latin maxims and terms. This forms a very important part of your syllabus because they have been asking the terms and the maxims very often, right? So this is very important from the viewpoint of your examination. Let's start. So before I begin, I would like to tell you that EduTap has come up with test series for both the phases, phase 1 and phase 2. It includes chapter-wise tests, sectional tests and full-length tests. For your revision, it will be very helpful. And we have also come up with the live crash course. The live classes, they are already going on. It is also for both the phases, phase 1 and phase 2. Apart from the live classes, you also get the test series that I have just mentioned, and you also get one-on-one mentor support. So if you are interested, you can refer to the link in the description below. Now let's start with the important terms and maxims. Question number 1. Which of the following is closest in the meaning of Latin maxim res communes? So what does res communes means? Res communes means things belonging to nobody, right? So they are things that belong to nobody but they are in use by everybody. Let's read it. Res communes is a Roman and civil law concept. It means things owned by no one and subject to the use by all. So they belong to nobody but they are being used by all of us, right? Things such as light, air, sea, running water, ocean, all of these are incapable of entire exclusive appropriation and are considered as the subject of res communes. Question number 2. When any law is said to be intra vires, it means the answer to this is option A. It means it is within the powers of the legislature and it does not go beyond the supreme and fundamental law of land, right? So if it is within the powers of the constitution, so it is known as intra vires, and the opposite of this is ultra vires. If it goes beyond the powers of the constitution, it is termed as ultra vires. If an act requires legal authority and it is done within such authority, it is characterized as law intra vires. Intra vires mean it is within that authority, it is within that power. If it is done without such authority, it is ultra vires, then it is outside the scope of that authority. Acts that are intra vires may equivalently be termed as valid. So they are valid, and those that are ultra vires, they are termed as invalid. So anything that goes beyond their authority, that will be termed as invalid, that is ultra vires, but within that authority, within that power, it is termed as intra vires. Question number 3. Which of the following statement is correct? De facto means in fact, de jure means by law, de minimis means about minimal things, both A and B, A, B and C. So the answer is E, that is all of these, they are correct, right? So we have done de facto and de jure. So de jure is something that is formally accepted. Like for example, I have told you that president is the de jure head of the state and prime minister, he actually has all the powers and he is what? He is termed as de facto. So that is in fact, he is the de facto head of the state. And de minimis is something which is too trivial, which is too minimal, right? Which is too minor. So all of these, they are correct. De facto means in fact, de jure means by law, de minimis means about minimal things. Question number 4. Which of the following legal maxim means written law? So the answer to this is option A, that is jus scriptum. So jus scriptum, it means written law, right? Jus scriptum means written law. Just non-scriptum means customary law, which is not written, it is customary law. Just means right or law, and jus soli means law of soil. Question number 5. What do you understand by the legal term habeas corpus? We all are aware of this. This is option C, that is bring the body or the person before a judge. So it is a writ that has been mentioned in our constitution and it means bring me the body, right? Bring the body or the person before the judge. So a writ requiring a person under arrest to be brought before a judge or into the court, especially to secure the person's release unless lawful grounds are shown for the detention. So you must have read this. It means you should have the body, or it means bring the body of person before the judge. So any person who is detained, he will be brought before the judge so that the judge can assess the legality of that detention. So this is what? This is habeas corpus. Question number 6. What is meant by doli incapax? So doli incapax means someone who is incapable of crime, right? This is option C. Doli incapax is a Latin term which means incapable of doing harm. This term has been used to describe a presumption of innocence for children in the criminal law in most countries. The basis of this presumption lies in the theory of criminal responsibility. So you must have read it in section 82 of IPC, where it is termed that a child that is below the age of 7, he is incapable of doing any crime. He is doli incapax, and that is why he has been given absolute immunity. So this is what doli incapax, which means incapable of crime. Question number 7. Ubi jus ibi remedium means, this is very popular maxim which means when there is a right, there is a remedy. When we were doing the Specific Relief Act, I have mentioned this term earlier. So it is ubi jus ibi remedium, which means whenever there is a right, there is a remedy to it. Question number 8. What is meant by persona non grata? So persona non grata is a person who is not wanted. It is mostly used in case of diplomats, right? So it is person not wanted. So that is option B, person not wanted. It refers to a foreign person whose entry, either his entry or retaining in a country, or that he is staying in that country. So that staying. So it is either the entry or his staying is prohibited by the country's government. So it is termed as what? It is persona non grata. Question number 9. What is meant by alibi? This is also very popularly used, that is alibi, and it has been given in section 11 of our Indian Evidence Act, right? So alibi is at another place. It is a defense that a person pleads that I was at another place when the crime was being committed. I was not at the place of the crime, but I was somewhere else. So this is what? This is alibi. Let's read it. A claim or a piece of evidence when an act, typically a criminal one, is alleged to have taken place. In a criminal action, a defense that the defendant was somewhere other than the scene of the crime when the crime was committed. So he is pleading, he is giving this defense that I was somewhere else. He is giving some evidence in regard to that. That is known as what? That is his alibi. That he was somewhere else when the crime was being committed. He was not present at the scene of crime, but he was somewhere else. So this is what this is. Alibi. Question number 10. Ipso facto means, this is also very popular. So the answer is by the very fact itself, right? So ipso facto, it is a Latin phrase which means that a specific phenomena is a direct consequence of the action in question instead of any previous action. It is used to say that it is reasonable to state or believe something based on the facts that are already known. So it is used to describe a situation that something is a natural consequence of another thing, or that it is a direct consequence of that thing, right? So it is ipso facto. It means by the very fact itself. Question number 11. Actus non facit reum nisi mensit rea. So it means option C, the act does not make one guilty unless there is a guilty intent. So it is not only the act that makes a crime, but also a guilty mind has to be there. It has to be guilty intention also. So the act does not make one guilty unless there is a guilty intent. An act does not make one guilty without a guilty mind. So guilty mind is also a prerequisite. This Latin phrase is often given as the pinnacle of the English common law criminal justice system and is usually in the context of mens rea. It states that for any act to be illegal in nature, it must be done with a guilty mind. So an act will only become illegal when it is also done, when it is a wrongful act, but it also has been done with a guilty mind, right? So this is actus non facit reum nisi mensit rea. Question number 12. What is meant by de minimis lex non curate? So de minimis, we have done something which is too minor. What is lex non curate? Now let's find out. So the answer to this question is C. The law does not notice trifling matters, right? So the law, it does not bother itself. It does not notice something which is too minor, right? Let's read it first. A common law principle whereby the judges will not sit in the judgment of extremely minor transgressions of the law. The principle that the law is not concerned with insignificant or minor matters. So it means that law does not care for, it does not notice the things that are too minor, the trifling matters, and it does not require any judicial scrutiny. So it is what? It is de minimis lex non curate. So if a matter, it is too trivial, it is too minor, you cannot go to the court for that matter. So this is de minimis lex non curate. Question number 13. What is obiter dicta? This is also very popularly used. So this is obiter dicta. Obiter dicta means reasons for being a part of the judgment, right? So it is a judge's expression of opinion uttered in court or in a written judgment, but not essential to the decision and therefore not legally binding as a precedent. It is a casual expression that the judge has given with regard to a judgment, but it is not the principle in that case. It is not something which will be followed by other subordinate courts as well. So it is what? It is obiter dicta. In a course of judgment, the judge may make many casual expressions. He may make many observations which are not binding, which are not relevant to the judgment. So all of these, they are termed as what? They are termed as obiter dicta. And there is another term which is ratio decidendi. What is ratio decidendi? It is the principle. It is the principle on which the judgment is based and it is binding on the subordinate courts, right? So that is known as ratio decidendi. For example, let's say that A was walking on a road and he found that there is a gold chain on the road, and the court in this case, it gave the verdict that it belongs to A by giving the principle that finder of the good is the keeper. In this case, this becomes the principle on which the judgment is based. So this is what? This is ratio decidendi, and anything that is not relevant to the judgment, any formal expression, any casual expression, it will be termed as obiter dicta. So I hope you are clear with both these, obiter dicta and ratio decidendi. Moving on, question number 14. Malum in se. So malum in se means bad in itself, right? Something which is bad in itself, that act is termed as what? Malum in se. It is a Latin phrase meaning wrong or evil in itself. The phrase is used to conduct assess as sinful or inherently wronged by nature, independent of regulations governing the conduct. So it is something that is inherently wrong. And there is another term, that is malum in prohibito. What does that mean? That is something which may not be wrong, but it is prohibited by law. It can be wrong also, but even if it is not wrong, it can be what? It can be wrong in the eyes of law. That is something is termed as wrongful by law, that is malum in prohibito, and malum in se is something that is bad in itself, that is evil in itself. Okay, I hope this is also clear to you. Question number 15. Caveat emptor means very easy. This also we have done earlier. So it is let the buyer beware. It is option number C, that it is the responsibility of buyer that he has to be aware before he is making any purchase. So it is let the buyer beware. It is the principle that states that the buyer alone is responsible for checking the quality and sustainability of the goods before a purchase is made. It is the law of commercial transaction, the principle that the buyer purchases at his own risk in the absence of an express warranty in the contract. So this we have done, that a buyer, he has to check for all the patent defects. So he is going to be liable. So it will not be the duty of the seller to reveal all the patent defects to the buyer. So in this case, we have done this. It is what? It is caveat emptor, that is let the buyer beware. Question number 16. Res judicata means, this also we have done. Res means matter and judicata means something that has already been adjudicated, right? So this is option C, that is a case which has already been decided. A matter that has already been adjudicated by a competent court and therefore may not be pursued further by the same parties. So this is kind of a bar, and this we have already done in CPC. This is res judicata, which means a case which has already been decided. Question number 17. What is meant by inter vivos? What is inter vivos? The answer is between living persons. It is mostly used in property matters when we say that transaction was between the living persons, right? So it is what? It is inter vivos. It is a legal term referring to the transfer of a gift made during one's lifetime under the subject of trust. It is during the life of the parties, right? During they are alive, that is termed as inter vivos. Question number 18. respondent superior means? So the answer is let the master answer, right? So respondent superior is a doctrine of law that states that a party is reasonable for the vicarious acts of its agent. In case of an agent and principal, the principal is liable. In case of servant and master, the master is liable. This common law doctrine was established in the 17th century. It is respondent superior, that is let the master answer. When the master, he is vicariously made liable, it is known as respondent superior. Question number 19. Volente non fit injuria means? So the answer is A. To a willing person, injury is not done. So if you have given your consent to an injury, it can be implied also, it can be expressed also. In that case, you cannot complain afterwards, right? You do not get that right. So this is what? This is volente non fit injuria. It is a common law doctrine that states that if someone willingly places themselves in a position in which harm might result, knowing that some degree of harm might result, they are not able to bring a claim against the other party in tort. So they are not liable to bring that claim once they have consented, they have given their consent, they are not liable to bring a claim against the other party. For example, in case of a cricket match, the players, they have impliedly given their consent. So for example, something happens to one player in the course of that game, in that case he cannot bring that suit against the other party. But you must remember that it should not be a deliberate attempt to harm. If it is not deliberate, then the defense of volente non fit injuria, it comes into play. Question number 20. What is meant by injuria sine damnum? This question is being repeated many times, so you should know this one also. The answer to this is B, that is injury without damage. That your right, injury in this sense means your legal right. A right has been infringed but no damage has occurred. So what it means? It is injury without damage. It means that injury caused to a party without actually suffering any physical harm or damage. The injury pertains to the infringement of a right pertaining to a person. The meaning of the above maxim is the infringement of an absolute private right without any actual damage. What this means is that your right, your private right, it is infringed but no damage was actually caused. So it is what? It is injuria sine damnum. For example, you all must have read the case of Ashby versus White, in which person was going to cast his vote. He was going to cast vote to his favorite representative, but he was not allowed to cast that vote, right? So here his right, it got infringed, but at the same time what happened? That person, that representative, he won. So in this case, no damage, no actual damage was actually caused, but yes, his right was infringed, and that is why it was what? He was liable to get damages. This is what? This is injuria sine damnum, when your legal right is infringed but no actual harm is done. It is injuria sine damnum. And the other term that is related to this, it is damnum sine injuria. It is opposite to this term. When damage is actually being caused to you but no legal right is infringed, it is then termed as damnum sine injuria. For example, A, he is running a shop of flowers and he is doing very successfully with that shop, but B also opens a shop adjacent to him and starts selling flowers. In that case, A's business, it's getting hampered, right? In this case, usko actually damage hua but his no legal right is infringed, right? Because if someone is opening a shop adjacent to you and doing the same business, it is no infringement of any legal right. So this is termed as what? This is termed as damnum sine injuria, when no legal right is infringed but you actually suffer some harm. But for damnum sine injuria, you cannot move to the court because there is no legal right that is being infringed. I hope this is also clear to you. Now question for achievers. What is meant by caveat? Is it a decree, a order, a direction or a warning? So you have to comment the right answer below. So that's all for today. I hope this session was helpful to you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.